Good afternoon, all.
Good afternoon.
Detective Cassim,
Yes, Your Honor.
how can I help you today?
I'm here on the Alexis Alexander case. I had a subpoena from the lawyer.
Thank you.
No problem. There should also be Sergeant Bettendorf should be joining as well.
Okay. I am looking for Water's Edge and Finley.
I am here, ma'am.
The attorney's coming right in, Judge.
The attorney's coming in on Water's Edge. Give me one moment. Oh, Marianne. I just had what happened there? This is 212567 LT Water's Edge Apartments versus Latasha Finley.
Good afternoon, Carolyn Cohen, P49391, appearing on behalf of the plaintiff.
Good afternoon, Ms. Cohen. And Ms. Finley, unmute yourself, state your name for the record, please.
My name is Latasha Finley.
Thank you. Today is the day and time set for the hearing on the non-payment of rent complaint previously filed in this matter. Ms. Cohen, are you ready to proceed?
Yeah.
Ms. Finley, are you ready to proceed?
Yes, ma'am.
Unmute yourself, ma'am. The last time we were here, there was some indication that there was an outstanding ledger request from Wayne Metro. Has that since been addressed, Ms. Finley?
So no, it has not. And then I did the SIRA application and I was supposed to hear back from them and I still have not. The deadline that was just yesterday though, but I submitted it the same day we had court on the 1st. Either the 1st or the 2nd, but I still haven't heard anything.
The last email I got from Wayne Metro was that you appeared to be ineligible because you were over the income threshold. That's the last email that I got. They were trying to explore some other income options to salvage the case, but I haven't heard that it was anything new had happened.
So I did receive that email. They said that I sent the wrong tax return. So they had me resubmit pay stubs. And that deadline was yesterday at midnight, I believe, but I sent it 2 weeks ago. And I haven't heard back from that response. I did receive that I was over the income threshold, but that was because I sent the wrong tax returns in. They didn't want 2020.
Okay, so is Ms. Cohen, is your client still willing to participate with the SARA? Well, not willing to participate. Is your client anticipating payment of the past due rent by SARA? Should I adjourn the matter is what I'm asking.
I think that if Ms. Finley doesn't disagree that she owes the money, that we should enter into a consent judgment that either she pays or if she gets approved, that Wayne Metro will pay. But the time, the 45 days is definitely passed.
Yes,
so
ma'am.
I don't think we should keep adjourning this.
Ms. Cohen, how much rent does your client claim due as of today's date?
$3,985 in rent and $156 in court costs.
So originally, I'm sorry to cut in, but originally this plan was because they were saying that I didn't pay rent from previous months. They waited to tell me like 4 months later, like, hey, we didn't receive this, which my bank had showed that it pushed out. So that's where the beginning discrepancies came from.
Ms. Finley, where we are this afternoon is that Water's Edge filed a non-payment of rent complaint back on June the 11th. When the parties appeared for the first hearing on June the 30th, there was an indication that the SARA application had been filed. In keeping with the administrative order in effect, the matter was stayed, which means no additional proceedings until this court received a request to lift the stay and proceed from the plaintiff's office after the time allowed had passed and their client, Water's Edge, had not received payment in full. So Ms. Cohen is correct. We are well past the time allowed for the stay. I asked about Sarah because if she voluntarily wanted to adjourn the matter, we would, but there is no basis for it, given what the Administrative Order 2020-17 says regarding stays for Sarah applications. So my question to you is, are you disputing that $3,985 is due in rent?
Yes.
Okay. Ms. Cohen, do you have your client or your witness here?
I can have my client here within the next 5 minutes.
And your ledger, has it been previously? I'm just flipping through our file to see if I have it. I don't see it. If you can get your client on the phone, I'll get the matter recalled as soon as possible. In the interim, there's 3 other trials scheduled for this afternoon. Would it be beneficial at all to go into a breakout room with Ms. Finley to discuss the ballots?
Sure.
Marianne will get that taken care of. And if you're unable to come up with an agreed upon rent amount, I will recall the case and we'll take testimony regarding the balance that's due, okay?
Okay, thank you.
Thank you. This is 213108 LT, Sharon Van Buren versus Nicole English Nelson.
Here, Your Honor.
Hear your name, please, ma'am.
Van Buren.
Thank you.
Morning, Your Honor.
Counsel,
Ryan Stern on behalf of Nicole Nelson.
thank you. Mr. Stern, the court did receive your appearance. It is in the court's file. Today is the day and time set for trial. Mr. Stern, are you ready to proceed?
Yes, Your Honor. There is some confusion as to whether this complaint was served for monetary damages or not. I was told that there was no personal service on this one, so I'm not sure about the monetary claim. With regard to the possession claim, we're not going to dispute that, and we are going to move out.
I'm sorry, you're not disputing that plaintiff has a right to possession?
Yeah, the lease terminates today, Your Honor.
Okay.
And my client is going to be out hopefully tonight, if not by tomorrow, but with a 10-day writ.
Ms. Van Buren, were you able to hear Mr. Stern just now?
Yes, I did.
Okay, so inasmuch as they being the defendant buying through her attorney are not disputing that you have a right to possession, the court would accept a judgment giving you the right to possession.
Okay, Your Honor, I paid extra for the money judgment, and I don't understand why they're saying, because half of the water bill was part of the rent. I don't understand why he's saying that she didn't know that.
What the attorney said, if I'm understanding him correctly, is because you did not have personal service on the defendant, that you are not entitled to a money judgment. Is that what you're saying, Mr. Stern?
Correct, Your Honor.
Your Honor, there was an officer that did deliver that to her. She would not answer the door.
I understand that, Ms. Van Buren, but the issue is, this is a termination of tenancy complaint.
Yes. Yes, and she did move out on September the 11th, Saturday, but she's been back there every day harassing me. and I do not appreciate it. And I want that,
Well,
I want that noted to the court. I had to call the police on Sunday over her. And she's accusing us of stealing things out of the yard.
Your Honor, if I,
okay, wait 1 second. She moved out on the 11th. Did she turn over keys to you?
No, she didn't. She did not. But I watched them move out their stuff.
Your
Okay.
Honor, we're still in
Ms.
the
Van Buren,
process.
hold on 1 second. Who is that talking?
That's Nicole Nelson. I apologize.
No,
We're still
ma'am,
in
you
the
haven't-
process.
Nicole, shush.
You have an attorney. Your attorney has indicated to the court that you are moving from the property. And I just wanted to confirm whether or not Ms. Van Buren had received possession of her premises back, because that would change what was on the judgment. But inasmuch as a plaintiff, go ahead, Mr. Stern.
Your Honor, they have not tendered possession yet. Moved out on this weekend. There are some personal properties still left there that she plans on getting out ASAP. So
And you interrupted me because it was different from what I was already saying?
I am so sorry, Your Honor.
No, don't apologize. I always think maybe I'm not saying it the right way.
No, you
So
are.
Ms. Van Buren, you filed a complaint for possession of the premises, termination of tenancy. The
Yes.
tenant is in the process of moving out. You can submit a judgment to the court
Okay.
that shows that you have a right to possession of the premises. You can, Mr. Stern, is the 10-day statutory time sufficient?
Yes, plenty, Your Honor.
Ms. Van Buren, do you understand what the court's asking you to submit?
Not really. Because she's actually moved out. It's just that she hasn't given me my key yet.
She's not, you can't retake possession by force right now. You don't have a right to the premises as of yet. Mr.
Right.
Stern has indicated that his client will be out of the premises. What I will say to you, Ms. Van Buren, is your phone number is on your complaint. If you have questions about your judgment, you can speak to our civil department about it. It's not something that I can walk through, or that I'm going to walk through online with, on YouTube and Zoom with you. But the civil department, I've made a note in the file that possession is to the plaintiff, that the plaintiff will submit a judgment providing the defendant with 10 days to move, as Mr. Stern has already indicated that his client is gathering her personals.
Okay. But Your Honor.
Anything else?
Yes, Your Honor. They are harassing me. I do not appreciate that. Now, I've already called the police once, but I am over there working on a second apartment in the building. It's a duplex, and they are coming back every day and just going in and coming out there in the yard and harassing me. And
Ms.
I do
Van
not.
Buren, Ms. Van Buren, I don't imagine that Mr. Stern, hearing that, would not address it with his client. I cannot believe that Ms. English Nelson would like a criminal complaint arising out of her getting her property. If she doesn't know how to come to the premises and take stuff without looking at you, talking to you, or whatever it is that you're saying she's doing to harass you, that's an issue between you and the public safety department. This matter is before this court only on the termination of the tenancy. The court's giving you what you want. Submit a judgment. You can talk to the civil department about what that judgment, how to do that, how to submit it either electronically, mail it into the court, or physically come to the counter and do it.
I will do that, Your Honor.
Okay. And Mr. Stern, I'm sure, like I said, will talk to his client regarding how to remove her property without causing any additional issues to you.
Yes.
Okay.
And I will.
Anything else, Ms. Van Buren?
No,
Mr. Stern, I cut you off. What were you about to say?
I was just going to say that I'll contact the plaintiff and make arrangements for transferring the keys in possession also within that time frame.
Wonderful. Thank you so very much. Anything else, Mr. Stern?
No, that's it, Your Honor.
Thank you. We're all set. Ms. Van Buren, have a good day, ma'am.
Thank you, Your Honor.
Ms. Cohen and Ms. Finley.
We got switched out of the breakout room in the middle of our conversation.
Marianne will put you back in there.
Thank you.
Thank you. This is 213337 Country Meadows versus Betty Riley, and Alexis Alexander.
Your Honor, for the record, Attorney Ian Morton of Pallets Law on behalf of Country Meadows P67892.
Ms. Alexander, state your name for the record.
Alexis Alexander.
Last time we were here, defendant number 1, that being Betty Riley, was not present. Where is she this afternoon?
My grandmother's still in the hospital, not looking so well with COVID, not doing well. But she is aware. Before I found out it was getting worse, she was aware of everything that was going on, so.
Mr. Morton?
Your Honor, what I can tell you is that, I did speak to Ms. Alexander. We do have proposed agreement in place, as this is a just cause termination. As you can see, I have, Detective Kassam present along with my client, but we do have a proposed agreement on a move out date. If the court would like, I can also put a term in there that before a writ could be entered on the agreement, we could have a hearing on that as well. If the court would like to then address it at that time, as the agreement that we proposed to enter into, that I spoke to Ms. Alexander about, would be to agree to a move out date of October 1st, 2021 in a conditional dismissal. Which would give them the rest of this week and the rest of the next 2 weeks to the end of the month to be able to vacate and turn over possession of the property. Our intent would be to default Ms. Riley into the agreement, so there would be no judgment entered against her. And if the court wishes, based on Ms. Riley's situation, to be able to have a formal hearing on a writ if necessary at that point, just so she has notice to make sure there's no adverse effect in regards to her. But we think that agreement's reasonable, Your Honor. So we would ask that that be entered.
Ms. Alexander, were you able to hear Mr. Morton just now?
Yes, sir.
Was that your agreement to move from the property by October 1st, 2021?
Yes, I don't want to cause any more problems. I just, want to move forward and just try to make the best of what I can.
Is October 1st sufficient time for you to vacate, you and the other occupants?
It's just me and my 3 kids right now. It's not, but right now I have to do what I have to do.
The court can't make Mr. Morton allow more time, but because of the issues with Ms. Riley, that's why I'm asking. I saw the lease and who's listed on the lease as occupants. And so if the first is what you believe you're able to do, and that's what you want to agree to, the court will sign a conditional dismissal that indicates that you will vacate by October 1st, 2021.
That's perfect, ma'am.
Okay, but what'll happen, Mr. Morton has indicated that any application for writ, should you not vacate by October 1st, will require a hearing. So if for some reason you have not vacated, turn the property back over to your landlord by surrendering keys and possession of the premises. If they file an application for eviction, you'll get a notice from this court to appear and provide a reason why an order of eviction should not issue. Understood?
Understood.
So consent as to Ms. Alexander, default as to Ms. Riley?
Yes, Your Honor. And again, we entered both as a conditional dismissal as to both parties.
Okay. And are you sending it to her for signature, or Ms. Alexander, are you authorizing Mr. Morton to sign on your behalf?
Yes, I authorized him to sign on my behalf.
Thank you. Make a notation in the file that Mr. Morton will submit a conditional dismissal for the tenants, both tenants, to vacate on or before October 1st, 2021. Any application for order of eviction requires a hearing in this matter. Anything else, Mr. Morton?
No, Your Honor. I just would like to add thank you to Detective Kassam for appearing, and you may be released, sir.
Thank you.
We're all set, Ms. Alexander. Thank you for working to resolve this matter this afternoon.
No problem. Thank you both. And you guys have a wonderful day and stay safe.
You too, and best wishes to your grandmother.
Thank you so much.
Mary Ann, why do I have loose papers? Have we seen Mr. Migas?
Not as of 122, no.
Your Honor, I believe this one's scheduled for 1:30.
It is, but I'm ever hopeful that people are early or whatever else.
I will text my client to make sure that they can see if they can log in right now as well, Your Honor.
Okay. Mary Ann, there's no point in me leaving because people will be coming. And Paige is on ever so. So I've told this story about Nemo the cat, which is what I'm calling this cat.
You mean you named the cat this morning?
I
Because
didn't name the cat. Paige found the cat close to Nemo's. And so if we can refer to the cat by that name, it'll be a little bit easier than saying that random street cat. So Paige is listening.
I suggested to Christine, since Chloe said that it was a girl, that we name her River, because I found her on here on River Drive. But
did Chloe take her to Romulus Animal Shelter?
No, she still has her. They're taking her to the vet on Tuesday. It's a little bit out there, but to just get a checkup before they either try to find her a home or.
Once they've had that cat, it was super cute, and I did mention it to corporate office, and yeah,
didn't go so well.
Didn't go so well.
Because Chloe keeps sending me. Chloe keeps sending me videos of her, and she's so snuggly.
Well, Judge,
she's too small for us. I'm sorry.
Did you show a picture? Oh, did you show a picture to the corporate?
No, you have to submit things in triplicate. The kitten was just too small, and
that's exactly why I said no. Because Emily asked me if I was going to keep it, and I'm like, Remy is just too big. Like, he just doesn't understand the concept of that little of something.
Our cat's good. Our dog is good with small things, but I have never seen her around anything that small.
Yeah, her paw is probably as big as she is.
Oh, easily. Our dog's first friend was a little, I'm trying to think of what this dog was. This dog was probably maybe an 8 or 9 pound dog, and our dog was already 20 pounds. And our dog would lay on the ground so this dog could jump on it and stuff.
Oh my God.
But that kitten is just too small. Miss Finley.
Yes, ma'am.
Were you and Miss Cohen coming out, or were you kicked out?
She is reaching out to my apartment manager because I have some disagreements about the lease, about the ledger, everything.
Okay.
And so I wanted to bring in the person that I've actually been in communication with. Because
So what we'll do is, there's only 2 more cases scheduled for the day, so yours and there's one other. So when Ms. Cohen comes back, we can figure out which case is going to go first.
I'm sorry, I can't. I'm trying to get a hold of the manager, and I can't. So I think the best thing to do is, I apologize, but let's adjourn it for another week, and we're gonna get together. I'm gonna have Ms. Finley go into the office and try to straighten everything out so she's in agreement with everything, and we can figure
Mary Ann, what's I'm trying to think. Not the 21st, but what does the afternoon of the 28th look like? Ms. Cohen, are you available? Ms. Finley, are you available?
I'm just looking at the yeah, that's fine. I mean, the 28th is fine.
Do you have a time just so I can inform my employer?
It will probably be 1 o'clock. I'm waiting for somebody to check my schedule for me because I didn't bring out that.
You're
I'm
open.
open. Oh,
yes.
Sweet. So if we say the 20,
I'm just curious.
September the
We're hearing on the 22nd, but maybe
on the
that's,
22nd with whom?
well, I don't know. I have first hearing, so maybe it's not you. I don't know. I just saw them.
First hearings are going to be with my resolve.
Okay, all right.
So if you're okay with going to, let's say, adjourn to 9/28 at 1 p.m. That'll be back with me, Miss Finley, back by Zoom, same Zoom ID. And if the parties aren't able to resolve it before then, and we know that the issue is the balance, if Ms. Cohen's office or her client wants to provide the court with a copy of the ledger or whatever it is, whatever documents you will be relying upon at trial, send them over. And same to you, Ms. Finley. If there's anything that you want the court to review or consider as part of the trial, it needs to be submitted beforehand so we can get it in the file. And you can either email it to the court, you can mail it to the court, or you can bring it. There's a drop box out front if you physically bring it to the court.
And I have a question. As
Yes,
far
ma'am.
as legally, like I can talk to her, right? Like about it, my apartment manager. Like, can we be in communication in reference to it? Like me going to the office and going over stuff, or no? Just because it's in court.
You absolutely should go to the office and talk to Rita and go over your ledger so you understand everything, okay? That would be the best idea.
Okay.
Anything else, Ms. Finley?
No, ma'am.
Anything else, Ms. Cohen?
No, thanks.
We'll see you on the 28th in the afternoon. Have a good afternoon.
Thanks.
Thank you.
Hey, Judge.
Hey,
Was-
Paige.
Was that at 1 o'clock? Is that what you guys said?
Yes, ma'am.
Okay, thank you.
Mary Ann, I'm telling you. Ugh. It's only 1:30 on the nose, so Mr. Megas appears. I will come right back out and bring these three files to you real quick. Oh, see, I know every time I stand up, it's gonna happen. Let's see. Good afternoon, sir.
Good afternoon, Your Honor.
How are you?
Oh, I am better than most.
This is 213433 LT, GINI 9 Harbor Club property versus Michael Megas. Appearances, please.
Your Honor, for the record, Attorney Ian Morton of Pallets Law on behalf of Harbor Club, known as the Waverly.
Your Honor, Michael Joseph Megas, complainant.
Thank you.
You're welcome.
We were last here on September 1st, 2021 for pretrial. There were some issues raised by the defendant. The matter was in fact scheduled for trial at 1:30 today. The court is in receipt of the plaintiff's exhibits to be presented at trial with a proof of service showing service upon the defendant on September 10th, 2021. Sir, Mr. Megas, have you received a copy of the ledger, the lease, and the addendums to the lease?
Yes.
Okay. And Mr. Morton, are you ready to proceed with trial this afternoon?
Yes, Your Honor.
Mr. Megas, are you ready to proceed with trial this afternoon?
Yes, Your Honor.
Sir, we did not receive any documents from you regarding your position or defense. Were there any documents that you intended to present to the court this afternoon?
Well, I was just going to basically do the best I can on explaining the situation at hand.
Okay, so what will happen is we'll swear in the witnesses who will testify. Plaintiff puts on its case first. You'll get an opportunity to cross-examine any witnesses he may have, and when he's done with his case, you will be able to present your defense, okay?
Yes, ma'am.
Is there any opening that you wanted to make, Mr. Morton?
Small clarification first, Your Honor. Would the court like me to share my screen with the lease or just simply refer to it as we move forward with my witness?
In as much as Mr. Megas has just referred to it because
Understood,
Mr.
Your
Megas
Honor.
has confirmed receipt of it. I have my copy right here, and we'll proceed that way, okay?
Okay, Your Honor. Okay, it was a very brief opening. This is a non-payment of rent case. With the court has a copy of the ledger, we will present the lease, the ledger, and show that there's a past due balance. Some part of the past due balance is accrued late fees. And underneath the lease terms, we would claim that those are due and owing. And at this point, we intend to move forward. We intend to request the entry of a proposed, judgment for possession only based on unpaid rent and related costs.
Thank you. Mr. Megas, was there any opening statement that you wish to make?
Oh, well, yeah, I did pay my rent in full. And I understand about the late fees. And I was hoping that you would be kind enough to waive these late fees under the circumstances that when I moved in, and I want you to take a look at this because you see that windows. No, I just wanted to show you. Go ahead. I'm sorry.
No, I was going to say, I remember your issues from before. And
Well,
the opening is just, the opening is just the summary. The opening is the summary of what it is that you intend to present this afternoon. So
well,
we
the
can
summary
get to
that I have presented this afternoon, and I apologize, is I've asked these people so many times to fix these things. The last time you even heard, my bathtub still don't hold water. I got water comes through my window when the window's closed when it rains. The windowsill's all dry rotted. That's what it looked like when I moved in. And, you know, the carpet stinks and nobody seems to want to do anything. So I thought maybe I'd step up to the plate, seeing that I run a 5-star company, and I'll do it all myself and just bill them. I've waited 9 months.
Your Honor, I'm going to object at this point, as I think we're moving past a opening statement.
This is
we are. So Mr. Megas,
yes, Your Honor.
I hear you, and you'll get an opportunity to show that information.
Yes, ma'am.
But we're going to start now with the plaintiff's first witness.
Yes, ma'am.
Your
Thank you,
witness, Mr. Megas, you should probably mute yourself. Thank you. Your first witness.
Thank you, Your Honor. This time we'd call Stephen St. Louis.
Mr. St. Louis, raise your right hand for me, please. Do you swear or affirm the testimony you give in this matter will be the truth, the whole truth, and nothing but the truth?
Yes, Your Honor.
Thank you. Put your hand down. Mr. Morton, please proceed.
Will you please state your name for the record, please?
Stephen St. Louis.
Thank you. What is your current employment?
At the Waverly on the Lake, I'm the general manager.
Okay. And how long have you held that position?
Since January of 2020.
Thank you. And in that position, are you familiar with the, was it residents and tenancies of, was it of the tenants that reside in the community?
Yes,
Okay, and specifically, are you familiar with the residency of Mr. Michael Megas?
yes.
Thank you. And from your, was it, where does what apartment or unit does Mr. Megas reside in?
48911 Denton Road, number 203, commonly known as 26203.
Thank you. And does Mr. Megas have a lease agreement with the community?
He does?
Okay. And was it everybody should have a copy of the lease agreement that Mr. Megas has? Do you have a copy of that in front of you, sir?
I do.
Okay. Does this look like a document or a agreement that's commonly prepared when a tenant enters into the lease of the property?
Yes,
It's the common business practice of the community to be able to create this document?
yes,
Okay. And do you create this document to confirm the terms of a tenant's lease?
yes.
Okay. Underneath the terms of this agreement, what is Mr. Megas's rental rate?
Base rental charge is $1,180 per month.
Okay. And if Mr. Megas is past due on his rent, is there any late fees that accrue?
There is
And what are those fees?
$100.
And additionally, beyond that, does he also get charged any utilities?
He does.
And what are those utilities?
Flat rate, $60 per month.
Okay. And he's responsible for those underneath his lease term, correct?
That's correct.
Okay. Next, actually, specifically just referring to the lease itself, I'm going to, point to page 7 of 8, which has an electronic signature on there of the resident. Is that Mr. Megas' signature from your knowledge?
Yes,
And who co-signed the agreement? Who on behalf of the community signed the agreement?
thank you. Lauren Kleeman,
And what is her role?
she's the community manager.
Okay. Next, I'm going to refer you, to the ledger. Do you have a copy of that in front of you?
I do.
Okay. As of September 1st, 2021, which was the day that the ledger that we submitted to the court, what was the balance due and owing at that time?
$1,560.
Okay. And then since the creation of that ledger, has another late fee come due?
It has
Okay. And what is that new balance according to the records?
$1,660.
Okay. And from your review of the ledger, is this a document that is kept? Was it related to Mr. Megas's tenancy?
Yes,
And why is it kept?
to track rental payments and lease charges for the terms of his lease agreement.
Okay. And the rental charges and application of funds, is accurate to your knowledge and understanding of his residency, correct?
Correct, yes.
Okay. And then, so this is a document that's regularly held and used, was it in the residency of Mr. Megas and all tenants, is that correct?
That's correct.
Okay. And at this time, are you asking for a possession judgment be entered against Mr. Megas for that $1,660,
Yes,
along with court costs accrued?
that's correct. Yes,
Would that be $167?
that's correct. Yes.
Okay. And then since the last hearing date, have you had or received any communication from Mr. Megas? Regarding any condition issues or anything of that nature?
I have not. No,
Okay. To your knowledge, has any of your staff members, received any emails or any communications regarding any condition issues?
we have not. No.
Okay. And to your knowledge, the unit had been remedied based on the previous hearing?
That's correct.
Okay. Your Honor, we would move for entry of the lease and was it ledger that's been submitted to the court underneath the business records? I have no further questions for my witness at this time.
Mr. Mingus, any objection to the court receiving the lease and the ledger?
No, you can receive it.
They are received. And Mr. Morton has indicated that he has no additional questions for Mr. St. Louis. Mr. Mingus, do you have any questions for Mr. St. Louis about the things he's just testified to?
Well, the one thing, and I mean, I know it's meager, but it's $60, not $68, the utility bills. And
I'm sorry to clarify, it was $60. I'm sorry. I apologize.
You're fine, Mr. St. Louis. You really are fine. But I appreciate the fact that you just lied under the oath, because I've asked you several times, did I or did I not, when I move in, have the opportunity to fill out a list with the problems on my property? And I filled them out on day one. And then, of course,
Your Honor.
Mr. Mingus?
Yes.
Is there a question that you have for Mr. St. Louis regarding what you just stated? Is there an actual question?
Well, I wonder why it's taken all this time and still nothing's gotten done. I don't operate like that. I just couldn't. And if a guy worked for me like this guy, I'd fire the man.
You have an opportunity, if there's testimony you want to give about the repairs, requests for repairs, copies of documents that you request for repairs, work orders, whatever it is, you have the opportunity to ask that or to testify to that when it's when you're giving testimony. But for right now, if you have questions to Mr. St. Louis about any of what he has just testified to.
You know what? All I really want to say is, isn't there any way that people in life can just say, let the bygones be bygones? You know, I'll overlook everything that ever happened here. I've come to like this place with the view that I have, and I also want to renew my lease. And I'm not behind a whole lot. I can clear that up today, if need be. I was just hoping that you would be kind enough to waive the court costs, or not the court costs. I apologize. That would be nice too, but the late fees. You know, people are struggling today. You know that as well as I do. A lot of people are going through some hard times. The last
Mr. Mingus, hold on one second. Do you have any questions for Mr. St. Louis?
No, ma'am, I do not have any questions for Mr.
Thank you. Mr. St. Louis, thank you for your testimony this afternoon. Mr. Mingus, I hear you. I guess my question is, are you ready to proceed with your case in chief? Or, I'm sorry, Mr. Morton, did you have another witness?
No, Your Honor, no further witnesses.
Thank you. Mr. Mingus, I hear you. Is there some testimony you want to give at this time regarding this matter?
The only thing that I want to say, and we've already went over this, they offered me something they don't even have here. They don't have it. Yeah, I'm working on a guy's house right now. The kid's driving a Lamborghini to school and he's 16 years old. These are the kind of people I deal with. Okay, he lives next to Peter Carmano Cancer Foundation. And like I said, I know Judge Donald Coleman. He's a good friend of mine. I'm a nice man, but I don't like being lied to. Nobody does. And this whole thing's just been nothing but a lie to me and everybody else
Mr.
outside
Mingus?
of me. Yes, ma'am.
Raise your right hand for me, please.
Yes, ma'am.
Do you swear from the testimony you give in this matter will be the truth, the whole truth, and nothing but the truth?
I absolutely do, Your Honor.
Thank you, sir. You can put your hand down.
Thank you.
Now, your testimony, your defense to this non-payment of rent complaint is what?
Lack of giving me the satisfaction of at least coming in and fixing all these things that needed to be fixed. There's a list of them, and it's only getting worse. I got paint peeling off the wall. I'm okay with it, though. I mean, I don't want to complain. I don't want to bicker. You know, I just want what's fair, you know? I mean, think about this. You know, when you walk in and, you know, you're sitting in an office and you're told you're going to get this, you're going to get this, you're going to get this, and you get none of it. But they have two angles. The one angle would be to not apologize for lying, but offer
Your Honor,
you
I'm going to object about accusation.
Another place to live. Like they'll give you that angle. Oh, well, you know, if you don't like that unit, we have another one available. But they don't. Not for what they are offering. And with that being said, their other angle is, well, if you don't like it, you know, you don't really have to stay here, but you'll have to pay the 30 days and you don't have to sign a lease again. So no matter what, they're covered. They're covered, and they lie. I don't like people that lie. I mean, sir, come on, you got to back these people. If I ran this guy's company the way he runs it, it's an embarrassment, sir. And I never graduated high school, and I make $25,000 a month, okay? But I'm not that smart, sir. I'd fix the whole thing myself, but I'd like to bill somebody for it, and I'm not cheap. And I would like to continue to stay here, sir.
Your Honor, I'm not sure who's, I mean, he's talking to me, he's talking to Mr. Staples. I mean,
Well, you objected, and I never heard anything from the judge, so.
I think
just
she waved me
continued.
off.
I noted Mr. Morton's objection, and Mr. Migas, I remember when we were here we weren't here previously because we were still in the other building. I remember the case from before, and I remember your issues before, and you were working on another house. I don't think it was this Lamborghini house. You were working on a house when we were here a couple of months ago. So I understand.
Oh, we got 35 jobs going on a week. God's been good to me, you know, and
So
when you
Mr.
serve,
Migas,
go ahead.
I heard Mr. Morton's objection, and when someone's representing themselves, I do allow a little bit more leeway than I typically
Thank you.
would.
Thank
And
you.
because of the nature of the issues between the parties, but Mr. Morton is accurate, and his objection would have been sustained because the testimony you're giving is actually something that someone else said, so it'd be impermissible hearsay. But because of, we're talking about your residents in the midst of what we are in and your issues that you are alleging, I wanted to give you an opportunity to present whatever it is you wanted to present to the court. And by present, I mean, not just documents and exhibits, actual testimony. So if there was something else you wanted to say to the court regarding the non-payment of rent complaint. Are you disputing the rent?
No, I'm not disputing the rent. I owe them the money, but I was hoping and praying that I didn't have to pay the late fees. And like I said, I could ask this guy till I'm blue in the face. I'll just fix all the stuff myself. It's not really that big of a deal.
Anything else, Mr. Migas?
No, ma'am.
Mr. Morton, do you have any questions of Mr. Migas?
No, Your Honor.
Mr. Migas, is there any other witness you have or any documents you want to present to the court?
No, Your Honor, I do not.
Thank you, sir.
You're
Mr.
welcome.
Morton, any closing?
Your Honor, I would just simply say court has the proposed ledger along with the testimony offered by my client. We'd ask that we'd ask that a judgment of possession be entered based on the contract terms.
Any final words, Mr. Migas?
I leave it in your hands.
I've listened to the testimony of Mr. St. Louis this afternoon. I did review the ledger and the lease yesterday morning and could see where the late fees had previously been zeroed out after the hearing in the previous landlord-tenant case. And I remember that there were some repair issues alleged by Mr. Migas at that time. And what I typically do, and I can't say that I did when we were here before, is that I will say to you, if you have repair issues, you put them in writing, you deliver them to your apartment complex in the way that your lease requires you to do. You keep a copy for yourself so that when you come back and you say to me, well, I hope that you don't come back, Mr. Migas, but if you come back, you say to me, Your Honor, I did what you told me to do. Here's the list that I gave them of these things that have existed and persisted since I first moved into the property and they still haven't fixed it. And Your Honor, please abate the rent because of these issues. If the issues are affecting your use and enjoyment of the property, I will consider it and I will make that appropriate adjustment. But when I've asked you, Mr. Migas, what you've said to me is, I don't want the late fees. Unfortunately, sir, I will not do anything about the late fees at this time. And after hearing, I will enter a judgment that matches the amount that's claimed due in the ledger, that being $1,660 plus court costs for them being the plaintiff having to file this matter and proceed this afternoon. Mr. Migas, if there are repair issues, please do what is asked in terms of submitting it in writing to the waiver.
I apologize.
link.
I don't. Yeah, no, I apologize, but I did that on day one. It's all in writing. He has it. And it was also brought up the last time we were in court. So, I mean, I don't know what else to do. I
Are
can
you
only
talking
ask
about,
when I
we're,
moved
we're
in.
done as, we're done as to this afternoon's
Yeah.
trial, but this is a separate question. Are you talking about the move-in inventory where you walk through and mark what's wrong with the
right.
premises? Or are you
Yeah,
talking about some subsequent?
No, the where you mark and, say that, the refrigerator doors are installed the wrong way. They put 2 screws through a piece of plastic to adhere it to the work is shoddy. It's all I'm saying. It's not professionalism by no means. And, I go for professional and they don't have it here. But
What
I'll
I would
fix
say
all
to
the
you,
stuff.
Mr. Migas, is, you said
Go
you'll
ahead.
fix it.
I'll fix all the stuff. Ma'am, I could build your house.
Don't do that, because then it'll show up as a damages issue. What I'll say to you with Mr. St. Louis still on the line is, if you have specific repair issues, in writing to your complex's community office.
Yeah,
And if you come back again, we'll address it again, but the court can't do anything without documentation. And,
I understand.
okay,
Yes, ma'am.
anything else, Mr. Morton?
No, Your Honor.
Anything else, Mr. Migas?
Do I get to stay here?
Of course, you pay, you stay, sir. That's what the case is. It's a non-payment case. You pay, you stay.
Okay, well, I'm gonna
We don't
pay.
pay,
and
we
I'd
have
like-
a different conversation. Why is
No.
Mr. St. Louis raising his hand? Uh-oh.
I just have one point of clarification that I would like to make, if possible.
Was it, Stephen? Well, we can talk after. What was it? We got the judgment. We'll talk after. It's okay.
Okay.
Thank you.
Take care.
Thank you.
Thank you,
Honor.
Mr. Morton.
Thank you.
Thank you.
Was that it? Oh, Thank you, Paige. Thank you, Mary Ann.